Attorney Ward, can you tell us about grandparents' rights to visitation in Connecticut?
Concerning grandparents' visitation rights, or the visitation rights of any third party, there are constitutional limitations on that based on decisions passed down within the last decade by the United States Supreme Court. The constitutional limitation flows from the fact that under our Constitution, the right of the government to interfere in family decisions is limited by the Bill of Rights that individuals have in the Constitution. And in order for a grandparent to obtain visitation with a grandchild over the objection of a parent, they have to go to court, which is a branch of government. So a court is limited in the orders that it and the circumstances in which it can order a parent to allow grandparent visitation. In the first instance, where there is a fit parent objecting to visitation by a grandparent, there must be a family disruption, such as divorce, separation, or death. A grandparent would not be allowed, for example, to go to court to get visitation rights regarding a grandchild who was the child of a married couple who were fit parents. Under the Constitution, it's for those parents to decide what visitation and contact the grandchild may have with the grandparents. Where there is a family disruption, then a grandparent may come in seeking visitation, but there are particular things that they must prove. And in the first instance, to begin the process, the grandparent must file an affidavit, sworn affidavit, showing specific facts that include, one, that up to that point in time in the past, they've had a, quote, parent-like relationship with the child. That's a special relationship. It's not likely, for example, that a grandparent who lived 2,000 miles away from a child and saw the child perhaps once or twice a year on holidays could prove that they had a, quote, parent-like relationship with the child, and they would not be able to meet that burden. The second is they have to show specific facts showing that denial of visitation will cause significant harm to the child. Now that's a different standard than the general standard of best interests of the child that's used for deciding custody and visitation between divorcing parents. It's common sense that in the general case it's going to be, quote, in the best interest, a good thing for a child to have contact with his grandparents. Most grandparents are loving grandparents who it's helpful for the child to have a relationship with. Those two categories that I just named, parent-like relationship and that denial of visitation will cause significant harm, are what in law is called standing questions. Unless you can present facts showing those things, the court will not even allow you a hearing. If you present facts showing those things and have a hearing, then at that hearing you'd have to prove those facts by clear and convincing evidence. Now that's a legal standard of proof, and at law these legal standards are best understood as words being the skins of ideas. But the idea behind those words are that it's a higher burden than the first level burden of proof, which is simply more likely than not. It's the middle burden between that and the burden in a criminal case of proof beyond a reasonable doubt. Often, in such a case, it would be crucial and nearly always helpful in order to prove that the denial of the visitation would cause significant harm to, if it's available, have the expert testimony of a psychologist or counselor for the child regarding that subject. In conclusion, in our society, it's becoming more and more common for grandparents to be involved deeply in the lives of their grandchildren, so that it's becoming more and more common for grandparent visitation rights to be ordered, but it's a strict process that requires strict proof and the help of a skilled and experienced lawyer to accomplish.